Hey everybody, and welcome to the first in a series of legal primers for furries. This one is the very first part one of OWO Notices Your Legally Binding Contract. I'm your host, the Boozy Badger, and this is a Boozy Bad Decision. So, how did this get started? Well, quite frankly, a lot of you kept asking me a whole bunch of contract questions. Mainly a lot of artists asking how they form contracts, how they can enforce contracts, what they should be doing contractually to make sure they have a legally enforceable agreement. And I thought, what the hell? I'll do something. So this is the result of that, and we're going to start today with part one. But before we get into it, I need to do a little bit of housekeeping with you guys, all right? Because you need to understand this is not a legal consultation. Only morons are going to take their legal advice from YouTube. Generally, it's a bad idea for guys like me who have law licenses to do things like this, because there's always the chance someone out there who would believe like WebMD telling them they have cancer is going to watch it and say, okay, now I know everything I'll ever need to know to have a legally enforceable agreement. So yeah, if I'm going to do this, I prefer to do it like where people can hear me and see me and ask questions of me if they really want to. But this is kind of the best stop, because a lot of you told me you don't go to conventions and you don't go out and sit through panels and things like that. So you wouldn't have this information otherwise. So, just generally, please remember, this isn't a legal consultation. This is not a replacement for you going to talk to a lawyer who's licensed in your jurisdiction to get more specific information. That said, what this isn't. This is not legal advice of any sort. It's a very high-level educational overview of some basic contract principles that you can use and apply to help you understand how the law works in relation to taking commissions and things of that nature. It is not a comprehensive overview of any and all laws. It's more of a common law overlook, the underlying principles that almost every jurisdiction in the United States and in most of the English common law countries apply. It is not a specific review of laws that apply to every jurisdiction. The laws are going to vary even if the underlying principles are the same. Every state is going to have some different rules by case law, by statute, things like that. So for a really specific view, you've got to go to a lawyer in your area to find out what the exact application is. And this is not protected by attorney-client privilege. If you put something in the comments section, first, I hope you're smart enough to realize comments are public anyways, but anything you say to me in response to this, it's not going to be protected by any type of privilege because I don't represent you. Nothing in this presentation creates a form of legal representation. I'm not your lawyer. You need a lawyer in your area who can talk about your specific circumstances. Whether you believe it or whether you don't believe it, the law is really complicated and state-specific. I can give you a general overview of these principles and explain them and try to educate you a bit, but only an attorney who's licensed in your jurisdiction and is familiar with your jurisdiction's specific laws can give you actual answers to all of your legal questions. That said, what is this? Well, this is fun. This is informative. This is an overview of some common law principles that often apply to contract and art law. And when I say common law, I mean English common law. And it's a way for me to kill some time and act like I'm being useful and my life generally has meaning, which is something I'm severely lacking in this day and age. So part one, today's section, contracts. How the fuck do they work? The very basic concepts you'll see in contracts and contracting. Let me be clear right off the bat, oral contracts are enforceable. Despite what you hear, every contract doesn't have to be in some signed form of writing. Some contracts do have to be in that type of writing, but it's specific types or ones that concern specific types of subject matter. And that's because of something we call the statute of frauds. We'll talk later on about that and some basic contract defenses. However, you just need to take away from this one part of it. Oral contracts are enforceable contracts. They are legally binding. A court can hear the terms of an oral contract and can hold people to it. They're just a lot harder to prove because there's a lot of he said, she said, and there's no one piece of writing that sets forth all the terms. So in short, just because there's nothing in writing doesn't mean you don't have a contract. A writing, with some exceptions, is not essential to the formation of a legally binding contract. There are really only 3 requirements for a legally sufficient and binding contract. They are offer. Hello, I would like you to draw my fursona or create a giant carpet suit for me to wear, as I entirely lack shame. Acceptance of the offer. I too have no concept of shame, gentle person, and will gladly create these things for you. I assume you prefer not safe for work? And consideration for the contract itself. In return for your creation of my shameful obsession, I will provide you with a thing or several things which have value. Huzzah! We have conducted business. Of course, it's not going to be that easy as just having those 3 things. You should be asking yourself, when you hear that, what is an offer? What is acceptance? And what the hell do I mean by consideration? If the law was as simple as just saying offer, acceptance, consideration, any moron would be practicing law. So, what's an offer? Well, an offer is a manifestation of a willingness to enter into an agreement made in such a manner that it would lead a reasonable person to believe that their assent, given in the manner required, would lead to the conclusion of the deal. And here is the representation of every single one of you after hearing me read that. So let's break down an offer a bit. There's 3 basic elements to an offer: intent, definiteness, and communication. Intent is where the courts look at the words used and the circumstances surrounding the making of the offer to determine whether the person who's saying it, the offeror, intends to form a contract, meaning do they intend to be bound if somebody says, okay, I accept that. Definiteness is where the court looks to the terms contained in what everybody is saying is now an offer to determine if they're so clear as to require no further negotiation or discussion in order for the contract to be completely fulfilled. And that kind of goes to intent as well. If I express an offer in terms that are definite and set forth like price, what I'm supposed to be doing, when I'm supposed to be delivering it, and all of that, then it's more likely that I intend to form a contract than if I just say, hey, do you want me to draw something for you for $20? And communication. Courts will actually look at whether or not an offer was actually communicated and even how it was communicated and who it was communicated to, and determining whether they're making an offer or whether they're making what we call an invitation to negotiate. So here's the written for artists explanation of what an offer is. An offer is any statement or act that would lead another person to believe all they have to do is say, I accept, for both of the parties to be bound. Okay? And when I say any statement or act, courts have held that an act can be a form of making an offer. It is whether or not you have intended to be bound when you make these statements. It's not whether you specifically said it, but what type of impression you're giving other people. But even with that simple explanation, there are exceptions to what is and is not an offer, because some things seem like they're offers, but they aren't really offers. For example, advertisements. Courts have consistently held that a general advertisement, like a television ad, a radio ad, a newspaper ad, or even an advertisement you put out on your website, is not an offer open to acceptance, but is rather an invitation for someone to contact you and make an offer on the thing you're advertising. So say you put on your website, I will draw your fursona for $50. That's not really an offer because it's available to the general public, and it's more of an invitation for somebody to contact you and make an offer. You know, I will give you $50 to draw my fursona that you can then accept. The same principle applies to circulars and general offers and contracts sent out for bids. Now, even if they set out like all the terms, those are not treated as offers, and they're really not treated as offers because of how many people those are going out to at once. People will receive that, and maybe you'll have 20 slots open, but 100 people will contact you and say, yeah, I'll do that. You don't have to accept every single one. And the main factor, like I said, is the number of people that are taking a look at that are getting those terms. Those are treated as invitations to negotiate or an invitation for them to make an offer to you, the artist. Auction bids, and I'm touching on this even though it doesn't have a lot to do with furry artists and fursuit makers and things like that. But because the furry community has so many charity auctions, I figure it's a good idea to clarify this. Auction bids are offers, but they're offers with special rules. Auction bids are offers that are made and only stay in effect until the next bid is made. The second the next bid is made, the prior offer is no longer open to acceptance by the auction. Now, if there is no next bid and the hammer drops, well, then it's been accepted and it can't be revoked. I bring this up because somewhat recently I was at a convention that was going to take secondary backup bids, and there's a whole complicated thing surrounding that. But the fact is, the reason most conventions shouldn't do that is backup bids aren't legally enforceable. If somebody bids $750 on something, the hammer drops, and then they never show up to pay for it, the convention can hold them to that bid. They can make a contract or treat it like a contract and go out to collect on it. But if they say, well, the 750 guy didn't appear, but the next bid was 725, well, the 725 guy was released from his offer the moment a higher one came in. So he doesn't have to buy it. I mean, he can if he wants to at 725, but there's nothing legally inducing him to make that payment. It's just kind of out of the goodness of his heart, and he still wants it, and he still feels like paying $725 for it. Now, what are the legal effects of a valid offer once it's made? There's a few out there. The first one is it creates a right of acceptance. Okay, a right of acceptance is where you make an offer to, say, Sparkles the Glitter Pony, okay? You have it all set out. All Sparkles the Glitter Pony has to do is accept it. The right of acceptance is the right of Sparkles to say, I accept, and now create a legally binding contract. Now, I should be clear, the right of acceptance only exists in the person that the offer is actually made to. It's not going to exist in, like, Sparkle's brother Dan, who heard about it and now wants to contact him. If Dan does that, that's not accepting the offer made to Sparkles. That's making a new offer to you. Now, also, the person who makes the offeror, is the master of the bargain. That means that in their offer, they get to determine what the terms are, what the price is, what the delivery is. They can even determine the mode in which you can accept the offer. They can say, you can only accept this by emailing me prior to midnight on this date. And at common law, that's a lot of power. Statutes have kind of changed that a little bit, but at common law, that's a lot of power, because as we're going to see in acceptance here in a moment, you don't have any ability to negotiate specific terms of a common law offer. You either accept it or you don't. But you also need to remember, for everybody on the other side of this, offers can be revoked. They don't just exist forever. They're not going to hang out there forever and a day after they're made. And for artists, this is important, specifically because, as we talked earlier, what a lot of you guys are actually going to get are going to be offers that you can to do work that you can then accept or reject. But you do have to accept them in a certain amount of time. Now, how can you revoke them? All right. Revoking an offer has to be done at any time prior to acceptance of the offer. Right up until the moment that you accept in the manner that you're told you have to accept by, the person who's telling you, I'll give you $3,000 to make a fursuit for me, can say, I've changed my mind. But it can't be done if there's an option on it. Now, an option is not just holding a contract open. All right, an option is holding a contract open without any ability to revoke it. And that's like a little mini contract inside the main contract. Like there's the main contract, I'll make a fursuit, or I want you to make a fursuit for me for $3,000. And you say, I don't know, I need time to think about it. And they say, well, you know what, I'll give you an option to the end of the month. And that means that prior to the end of the month, they can't revoke that offer. They can't take it away. If you accept before the end of the month, then no matter what, they're bound to give you the $3,000 to create the fursuit. And this goes both ways. The catch with options are options actually require separate consideration from the main contract to be valid. Otherwise, they're not an option. They're just a time period, and time periods can be revoked at any point. You can't revoke if there's been detrimental reliance. I'll talk about that once again a little later under the consideration section. And on certain types of offers, you can't revoke once performance has started and substantial performance has been made. I'll talk a little bit later about what substantial performance means. But in addition to revoking an offer, offers also terminate. And the termination of an offer is done in several ways. It can either expire or lapse. Now, we talked a moment ago, like holding something open till the end of the month. If my offer to somebody says, you have to accept or reject this by the end of the month, that's a time frame. And at the end of the month, that offer's bad. It's no longer open to acceptance. Even if I don't say that, the law implies by operation of law that all contracts, all offers are only open for a reasonable amount of time under the circumstances. So if I make an offer or I receive an offer and 2 years goes by and I don't do anything or the other party doesn't do anything, there's a very good chance that they then contact me and say, okay, I accept it. The courts will look at it and say, no, more than a reasonable time has passed, even though he didn't put a time limit on it. So we're going to terminate it by operation of law. There's also rejection of an offer. At common law, any rejection of an offer made constitutes the termination of the offer. The offer is no longer open to acceptance once I've made a counteroffer to you. All right, so those are the general kind of terms on offers and how they can be revoked. But now we need to look at what acceptance is. Now, very, very, very generally, acceptance is simply an offer that is either an agreement to the terms of the offer or the performance of some act that's required to accept it. And I'll talk about that, but what you need to really know, acceptance is only open to the person that the offer was made to. A moment ago, we talked about Glitter the Sparkle Pony and her brother Dan. This is what we're talking about. Dan didn't get the offer. Glitters did. Glitters is the person who can accept it. At common law, you had something called the mirror image rule that applied. I'll get to that in a moment, but you really just kind of need to know you can't really change the terms of an offer. And acceptance has to be made in the manner stated in the offer. Offerors get to say how you can accept their offer. If they say, I will only accept the offer if, or the offer can only be accepted by payment, then you have to pay them. If they say you can only accept the offer by notifying me via email, then you have to notify them via email. Acceptance that is not in the form that the offer states can either be accepted or dismissed by the offeror, whichever they please. Now, if they don't state a form of acceptance, and this is kind of an interesting tidbit, the law says acceptance can be made in any reasonable method that places the offeror on notice that you have accepted. So how can an offer be accepted? There's three means of acceptance generally to an offer. The first is communication to the offeror. It's only going to happen if it's made in the right format, like the format that the offer says, what we were just talking about a second ago, email, phone. If the offer says you have to accept in this way, you have to accept in that way. But like I said, there's a little bit of wiggle room if they don't specify, because then it's any reasonable method that places the offeror on notice that you've accepted. And it has to be made prior to revocation. Now, quick side note on this, there's a question of timing, especially for like mail offers. I'm not going to get into that. The reason I'm not going to get into that is there's a very specific subset of contract law. There's a rule out there called the mailbox rule. It's very complicated, but it's basically when is acceptance valid, and when is an offer valid, and when is revocation valid, and which one matters to which one if they cross in the mail, and is it effective the moment you put it in the mailbox or the moment the other person receives it, and all that's just like really in-depth, and more in-depth than I can cover in just one presentation. You have to remember, guys, what I'm covering here is like the first 6 months of contracts in law school. So I can't get to everything in one YouTube presentation. Performance is another, and performance is going to be a means of acceptance if the offer is open to acceptance by performance. Like if I go back and I tell Billy, if you mow my lawn, I'll give you $20. I'm not asking Billy for a promise. I'm telling Billy, if you mow my lawn, I'll give you $20. So he can accept it by either saying, okay, or by mowing my fucking lawn. The funny part of this is, you know how a moment ago I was talking about revoking offers? Okay, so say I have an offer that's out there and it's open to acceptance by performance. All right, Billy comes over, he starts mowing my lawn. Now, Billy gets like 2 fucking minutes into mowing my lawn, and I walk out and I yell, I revoke. Has Billy created a binding contract? Used to be yes, because he had begun performance. The way they really treat it now is like substantial performance. And it doesn't have to be half of the performance that's been requested, but it could be. It just kind of really, you look at what the terms of the offer was, what I was asking them to do, and you say, did they substantially perform it? And once they've hit a certain point in that, the court's going to say, okay, well, now they've done so much of it that you no longer have the power to revoke. It could be 50%, it could be over 50%, but that's kind of where we are. A general rule of thumb is, say, at about 51%, you can be pretty certain the court's not going to let them just back out of any contract that they've offered you. So that's good. The third is silence. Okay, silence can be acceptance, but in order for silence to be acceptance, it has to be specifically stated in the offer that a failure to respond or silence on it creates acceptance. So, what if you want to negotiate those terms? Well, tough shit. At common law, the offeree, the person who receives the offer and has the right to acceptance, has absolutely no right or ability to accept some terms and negotiate or reject others. You either accept the offer as it exists or you don't. Any attempt to negotiate, any counteroffer, any communication back that says, I accept, but I want to change one thing in it, is a rejection of the offer. And as we found out earlier, rejections immediately end your ability to accept that offer. So if you make a counteroffer at common law, if you make a counteroffer and they say no, you can't then go back and say, okay, well, let's go back to your original terms because I still want to do it. They would at that point be accepting your offer to go back to the original terms. This is what I was talking about when I said the mirror image rule. The terms of acceptance must exactly mirror the terms of the offer. Remember, though, this is at common law. Common law has changed a lot. Contract principles have changed a lot. The mirror image rule is not as strict as it once was. Now it's kind of any counteroffer that changes the material terms of the contract, the ones that are really, really important to the performance, like price, delivery, things like that, would be a rejection. But minor suggested changes generally won't be considered a rejection anymore. So, you may be saying all you have to do really then is say, I accept. And the answer, the short one, is maybe. The long answer, the offer will generally say how you can accept the offer, and you must accept it in the manner provided for in the offer itself. What they do in this is they're kind of setting themselves up for a defense to it. All right, they didn't accept in the way I told them to accept, so now I'm not bound. Now, once again, common law rule has been lessened a bit. Some jurisdictions say as long as the acceptance is reasonable, even if the offer provides for a specific way, we're going to allow the contract to be formed. But it's always safe to read the offer, see how you can accept, and follow that. But there are exceptions, like I said, such as when there are no terms of acceptance stated in the offer. That would be like a situation where they don't say anything at all about how you can accept. And like I said earlier, in that case, courts will imply that you can accept by any reasonable means. Although the courts may imply that you can accept by any reasonable means, though, you need to know what type of a contract it is to know what means they're going to consider reasonable. Whether a contract can be accepted and how it can be accepted depends on whether it's what we call a unilateral or a bilateral contract. A unilateral contract is one where only one side is making a promise while the other side has to perform. Like, Billy in my last example. Okay, I go to Billy, I tell Billy, come and mow my lawn, I'll give you $20 when it's mowed. Billy is going to mow the lawn and I'm promising to give Billy $20. That's a unilateral contract. A bilateral contract, however, is where both sides of the contract are making promises. That is the modern default. The difference between that and a unilateral contract. In a unilateral contract, I'm telling Billy, mow my lawn, I'll give you $20. Now, if I go to Billy and I say, Billy, if you mow my lawn before the end of this week, I'll give you $20. And we shake hands on it, we walk off. Billy has promised to mow my lawn before the end of the week. I have promised to give him $20. That is a bilateral contract because what I'm really exchanging for, what we're contracting for, is a promise for a promise. The promise to mow my lawn in return for the promise of money. And that is the modern default. At that point, we have a binding contract. Under a unilateral contract, we're only going to have a binding contract when they start to actually perform. So, how do you accept a bilateral contract versus a unilateral contract? Unlike genders, guys, there's only these two types of contracts, so it's really easy to tell you how to accept them. Unilateral contracts, the only method you can accept them is by actually starting the performance that is being requested. And like I said earlier, substantial performance is generally the rule of when it's completely accepted and no longer open to revocation by the party that's made the offer. Bilateral contracts are accepted simply by making a promise in return, like signing a written contract or saying, okay, I'll do that, or shaking hands on the deal. And you can see why that's kind of the default. In a bilateral contract, from the moment the promises are exchanged, either side can enforce the contract. But every contract requires that you pay some form of consideration. And consideration is something of value that is given. It's literally anything of value that you bargain for. And while it can be money or property, it doesn't have to be. It can be a promise to act in a certain way. It can be a promise not to act in a certain way when you otherwise had a legal right to do so. We call that a promise to forbear or a forbearance agreement. And it's easier to tell you really what consideration isn't than it is to tell you what consideration is. Consideration isn't promising to act in a certain way when you're already required by contract or by law to do it. If you give me $50, I won't punch you in the face. That's not consideration. I'm already barred by law from not punching you in the face. You can't form a contract for something you're already supposed to be doing. It's not past gifts or benefits you've received from somebody. Just because somebody gave you a gift or did a favor for you in the past, that's not consideration for future contracts. It's not something that causes a benefit or detriment to only one party. Now, a quick word on this. When I say benefit or detriment, I mean each party either is receiving something or giving something up. And courts are kind of split on this. The majority of courts actually kind of require both parties to have a benefit or a detriment. For example, you're giving me $20, I'm getting $20. My benefit is I get $20, your benefit is you lose $20. Therefore, we are both benefited or burdened by the agreement, and it's binding. Some courts, a minority of courts, but some courts actually hold that only one party has to have a benefit or a detriment for there to be a binding contract. But if you're in one of the many, many states that don't follow that minority rule, it's going to be both parties, okay? And anything that is purely illusory, here's the best way to do that. Illusory consideration is something that seems like it's consideration, but when you really look at it, it's not, okay? Let's say we make a contract that says, I will buy 5 fursuits from you at $3,000 a piece. All right, there's consideration there. I'm getting fursuits, you're getting $3,000 per fursuit. Now, say I change that wording just a little bit. I will buy 5 fursuits from you at $3,000 a piece if I feel like it. If I feel like it means that I'm not actually bound to give you anything. I can say no at any point, and that means there is no consideration. The consideration of $3,000 is purely an illusion, and therefore there's no binding contract. But the law will not protect you from being stupid with contracts, guys. There's no requirement that what you receive in return for an agreement have the same legal or personal value as what you're giving away. It doesn't have to have equal value or greater value. It just has to have some value in return. The law won't stop you from making a bad deal. And consideration is not always technically required. Some circumstances don't need consideration because there's an exception. There's a replacement to consideration, such as promissory estoppel. This is kind of the detrimental reliance thing I was talking about earlier. That says you don't need consideration. If somebody makes a promise that they reasonably would expect someone to act on, the person who hears the promise is justified in relying on it being followed through, and they substantially change their position as a result of that. The classic example is like somebody knocking on your door and offering to buy your house, okay, for $150,000, and they leave. Now, maybe there's no contract at that point. But if I go and I sell and I start getting financing and buy a new house in anticipation of selling my house to that person, I have kind of changed my position substantially. And as long as I was justified in relying on that offer, then I don't need any consideration to be able to enforce it. But it has to be a substantial change. If I just go out and buy $5 in light bulbs for the new house, that's not substantial enough change. And it's very fact specific. So in that situation, the court will look at the circumstances surrounding the making of the contract. Now, there's also promises to pay barred obligations. Generally, there's not consideration needed for paying a legally unenforceable debt, but if there's no consideration needed, it requires a new promise in writing that has some new terms. You can't just be promising to do it out of the goodness of your heart. And that's a whole different thing. There is an area of law regarding old debts and promises that have expired, but I'm not touching on that today. Now, let's talk about some contract defenses. Defense is not just that thing that surrounds the yard. I'm not apologizing for this. Some contracts are void. That means they're never enforceable. They were never enforceable in the beginning. They're never going to be enforceable no matter what the circumstances are or whether a defense is raised or not. We call those void ab initio contracts, and they are kind of like this. Contracts with people who lack capacity. That can be mental incapacity, such as being adjudged by a court of lacking the capacity to manage your own affairs. That can be somebody underage, somebody below the age of 18, and I'll touch on that much later on in another section of these presentations. But general rule, people under the age of 18 can't enter into legally enforceable contracts. But it doesn't mean that somebody's like drunk or on drugs, okay? Drunks can create legally enforceable contracts unless they're like blackout drunk. In which situation, maybe they're not enforceable if the person who entered into the agreement is aware that the person was so far gone that they couldn't really agree to it. Illegal contracts. Any contract that requires people breaking the law is unenforceable as what we call a matter of public policy. You can't contract for somebody to do something illegal. Forces or prevents people to marry, same reason. It's against public policy. The courts won't enforce contracts that regard marriage. Impossibility. And when I say impossibility, I don't mean it's just very hard to do. I mean it is literally impossible for someone to fulfill the terms of the contract. Like if you get a job to paint a house that was demolished 20 years ago. And if the contract's based on a bet, the courts won't enforce contracts that are based on bets or gambling or chance. So those are just kind of big ones. There's other ones, but those are big ones to look out for in your contracts. Other contracts are invalidated only if you raise the defense to them. Those are voidable contracts. They're enforceable until somebody raises one of these defenses and proves it. These are generally what we call affirmative defenses. Amazingly one-sided contracts. We call that unconscionability. And I want to be clear, this is not just like a contract that isn't fair. Unfair contracts are okay legally, but contracts that are so unfair, contracts that are so one-sided that they shock the conscience of the court can be found unconscionable. And you see that a lot in defenses to contracts. They were unconscionable contracts. They don't succeed very often, but it is a defense. Contracts that are based on fraud or misrepresentation, with a few caveats. First, the fraud needs to be on a material aspect of the contract. Something is material to the contract when if you knew the truth about it, you wouldn't have contracted at all with the person. So maybe you think you're contracting with the King of Spain, but that's not material to the contract as long as they perform. The non-material fraud will not be a defense to the contract itself, but material fraud is. There's another caveat to that, though. If you know about the fraud when you agree to accept the offer and enter into the contract, it's no longer a defense. You knew about it. So you weren't justified in relying on the misrepresentation because you knew it was wrong. Mutual mistake. Mutual mistake is where both parties are kind of not having a meeting of the minds on one of the material terms. Say there's a material term that's like, we'll deliver in 6 months. Okay, now they're counting like 6 months from the date you first talked to them. You're counting 6 months from the date of first payment. That is a mutual mistake, and that may be enough to invalidate the contract. But a unilateral mistake won't be. A unilateral mistake is where only one party was mistaken, not both the parties. And in unilateral mistake situations, the courts have a tendency to say, absent something else, we're going to enforce them because everyone else knew what the contract meant except you, and you should have clarified it. The real big exception to that is if you know the other party is mistaken and you don't clarify it, then a unilateral mistake may be enough to get out of the contract. The statute of frauds. The statute of frauds is where certain types of contract, the sale of land, contracts that can't be performed in a year, contracts over a certain amount of money that varies based on which state it is, those contracts have to be in writing to be enforceable. That is a defense to the contract, but if you don't raise it, you waive it. And that's why I say it's a voidable contract. You have to raise that defense for the court to not consider it. And then there's contracts made under duress. Now, duress, you hear it a lot, is a situation where somebody enters into a contract because they don't really have any other reasonable choice open to them except to enter into the contract without suffering some great harm. Now, the harm, depending on your jurisdiction, doesn't have to be like sign the contract or I'm going to hit you upside the head with a ball bat. It can literally be if you don't enter into the contract and you have no other choice open to you, you're going to go bankrupt. Some jurisdictions actually do require like a threat of physical harm, but not very many anymore. So we've covered offer, we've covered acceptance, we've covered consideration, we've covered just some really, really basic defenses. And you kind of have to know all of those for what's coming next, because the next time we're going to be talking about specific contract terms and how courts interpret them. And doesn't that just sound like fun? I guarantee you it's not, guys. I guarantee you it's not fun, but you're probably going to tune in anyways. So I hope you've enjoyed this first part. It's a really, really, really high-level overview of the basic contract terms and the meaning of them that we're going to need to kind of discuss the contracts more in depth next time. And if you did like this, you want to support it, guys, you can always give me your money, and I promise I'll take it all out of the bank. I'll throw it on my bed, I'll roll around on it. It'll be fucking amazing for me, maybe not for you, but great for me. You can do that through the Ko-fi link, kofi.com, Lawyers and Liquor, or you can send it over through the PayPal, paypal.me/lawyersandliquor. And this is the Boozy Badger, and until the next time, guys, you have a great evening, and I'll see you all again real soon.